Pronouncement of judgment of item number 1.
Result, upon due consideration, I do not find any merit in the writ petition, and accordingly the same is dismissed, leaving the parties to bear their own costs. Mr. Gatto, take the records.
Yes.
Give him back the records. Okay?
Madam.
You mentioned?
Madam, I beg to mention item number 18 and 19, madam. It's connected matter, madam. I request some more time, madam. 2 weeks time, maybe granted to file counter affidavit, madam.
Yes. Also the other side.
Yes, Lord.
Any objection?
No, Lord.
Okay. How much time? 2 weeks time.
2 weeks, madam.
On the prayer of Mr. T. Tagu, Lanet, Standing Council,
18, 19.
Education Department. And not objected by the other side. Further 2 weeks time is granted for filing counter affidavit. List again after the ensuing publication.
Lordship, there is an interim order.
Interim order passed earlier shall continue in the next date of listing. Item 18 and 19.
Lordship, I beg to mention item number 16, Lordship, on behalf of B. Picha, Lordship.
Yes.
Matter may be list after puja break, Lordship. I
Have
take
you
an
informed?
Lordship. Lordship.
Mention has been made on behalf of Mr. B. Picha, Lanet Council for the
Petitioner, Lordship.
petitioner.
Lordship.
Item 17.
No, Lordship, 16.
Item number 16.
1-6.
16.
Lordship.
The effect that since the Learned Council is indisposed, matter may be posted again after the ensuing puja vacation. Learned Council submits that he has taken the consent of the other side. In view of above, list the matter again after the ensuing puja vacation.
Okay.
Lordship, I would like to mention item number 17.
Mhm.
Can you take up this matter on 24th of October, Your Lordship? I've taken the consent of the petitioner.
Okay, as paid for by Sarbasa, Learned State Council. This is the matter on 24th of October, 2025. Stop. Consent of the Learned Council for the opposite party has also been taken.
Okay.
Your Lordship, I beg to mention item number 20th, Your Lordship.
28.
Yes. Leading counsel, Bengi Arun is out of station, you know, due to medical emergency.
21.
After the puja vacation.
Okay, Mr. B. Arun, Learned Counsel for the petitioners is said to be out of station on medical grounds. Stop on a prayer made on his behalf and not objected to by the other side. Is this matter in after the ensuing publication?
Lordship, I beg to mention item number 15, 1-5.
Yes.
I'm for the respondent number 4, 7, and 8. We need to file our counter in this case. So we need some time for NSPC.
Then the HPC.
Yes.
What's your good name?
K. Saxena.
Mr. K. Saxena, Learned Counsel, appearing for the respondent and HPC submits that may be given. How much time?
3 weeks.
3 weeks time to file counter affidavit. So, have you informed the other side?
Yes.
Mr. Mao and all are there.
Yes. Taken consent.
Since since there is no objection from the other side, further 3 weeks time is granted. As paid for. List matter again after the ensuing application.
Okay.
Counter affidavit we file in the meantime.
Lordship, I take mention item number 26. I got a petitioner in this case. In this case, the step upon respondent number 7 is incomplete. So I believe I will allocate the fresh step.
Fresh. As paid for by the learned counsel for the petitioners. 3 days time is granted for taking fresh steps upon the. No, okay.
Respondent number 7.
Right, a week's time is granted for taking fresh steps upon the respondent number
Step 7.
7. Release the matter again after the ensuing application.
Thank you.
May I please, madam? My lord, I beg to mention item number 12.
Yes,
I am body respondent number 4.
yes.
My lord, matter may be adjourned today.
Respondent number 4.
Yes, ma'am.
What is your good name?
M. Doji, madam.
Roji. Why do you want adjournment?
My lord, the leading counsel Deep Angini had some personal difficulty.
I see. Then have you taken consent from the other side?
Yes, I have taken, ma'am.
All right. Leading counsel, Mr. Deep Angin, learned, who appears for respondent number 4, is said to have some personal difficulties to appear before the court today. Stop on a payment on his behalf and not objected to by the other side. That the matter will be decided again after
After vacation, ma'am.
the puja vacation.
My lord, item number 13 also.
Similar order. Okay.
My lord, can it be taken on 25th of this month, ma'am?
Item number 2.
May I please, Lordship?
Yes.
Lordship, directly come to the page number 16, Lordship, annexure 1. This case, Lordship, petitioner has occupied the one plot of land in the year 1990, which is the farmer, occupation by farmer.
Page number 6.
Page number 16, Lordship,
16.
1/6, annexure 1. Petitioner is occupation by farmer in the year 1992. He has occupied one plot of land. It's a blazer. So what happened? One day that the PHE department, respondent authority, they came and requested for this plot of land for the construction of some official and any other building of their PHE department.
No, item page number 16 is an undertaking.
Yes,
What does it
this is the root, Lordship. This is the root of the case, Lordship.
That's what you tell me.
Yeah.
What is the undertaking?
Undertaking is that, Lordship. I may read out, Lordship. Just respondent and the petitioner has made one undertaking. I, Sri Taba Chason of Sri Taba Hari of Tarajili village, Papum district, Arunachal Pradesh, do hereby donate my WRC land to PHE department, area measuring of 1687 square meter with the following terms and condition. Number 1, civil on the said proposed area for any kind of civil construction work. Number 2, the casual contingency beyond, if required, in future may be given Lordship, this petitioner has submitted one representation to the assistant engineer PHE division, Naharlagan. Lordship, what happened? here very clear it says that terms and condition may be complied because the wait for some more year, wait for some more days, like that. Given only assurance to the petitioner. They have, see the page number, Lordship, page number 24, last page, Lordship. Page number 24 is the first that how the building constructed by the respondent authority in my land, despite of having these two terms and conditions, Lordship. Page number 24, Lordship. And page number 23 also similar in my plot of land, despite of my request. Thereafter, in 2017, Lordship, page number 20, Annex 3. Again, this petitioner has submitted one more representation to the respondent authority.
Page number
20, Lordship, 20, Annex 3, in 2017, after 7-8 years. But they were continuously doing their work. They were constructed SP type building, their office was also functioned, but they have not complied these terms and conditions. So because of that, Lordship, in page number next, Lordship, page number 21, Annexure 4. In recently this year, March 19, Lordship, petitioner has very recently submitted one more representation. His third time, Lordship, as a farmer, Lordship, submitted seeking enforcement of undertaking terms and conditions dated 24/0/2005, executed in between myself and PhD. In here also made a prayer to comply, to go as per the terms and conditions dated. But till that, Lordship, problem is that they are not responding my representation, Lordship. Till then. But now, Lordship, see the page number 22, Lordship. This is the latest photographs which the PhD department, they are constructing. Now they are constructing ours is a 2-3 stories building, despite of having this undertaking deed of documents.
will issue notice. Will issue notice. Who's for the others? Pasar, you have obtained instructions. Part Mr.
Deed of Lordship.
Itopu, learned counsel for the petitioner who submits that the petitioner had entered into agreement with the assistant engineer, PhD department, Itanagar division on 14/4/2005. The effect that for the donation of land made by the petitioner, measuring an area of 1687 square meters, the PhD department would be awarding civil construction works to the petitioner, he being the landowner. So further, the casual contingency beyond, if required, in future may be given in consultation with the landowner. So the learned counsel submits that despite such an undertaking and understanding reached between the parties, the PhD department has not kept, has not fulfilled its part of the bargain and has constructed buildings in the said plot of land. Not engaging the landowner. The petitioner had submitted several representations. The last representation was on 19/3/2025. But the respondent authorities have failed to consider same. Stop petitioner having no alternative as is before this court. Next para issue notice. Notice of motion returnable by Bowitz, Ms. Arbasa. Common advocate accepts notice on behalf of all the respondents.
Yes.
PhD,
Yes.
there's a standing counsel?
No.
On behalf of all the respondents, petitioner to furnish requisite copies of the writ petition to the learned government. Next, para also issue notice on the interim prayer, returnable by 4 weeks. Learned government advocate shall obtain instructions by the next returnable week.
Much of it.
Item number 3.
If I may, my lord.
Yes.
My lord, this petition challenges the impugn orders, annexure 9 series, page number 61. My lord, by these 6 orders, the ST certificates of the petitioners were cancelled by the
Page 51,
page 61, my lord.
61.
Yes, annexure 9.
How many petitioners are there? 6.
6 petitions.
6 petitioners. ST certificate cancelled.
Yes,
Okay. Petitioners belong to which tribe?
Adi.
Okay. Why was it cancelled?
My lord, as reflected in the order, the reason given is for misrepresentation and ineligibility.
Huh?
The page,
Where? Please read.
page number 61.
61.
Yes, my lord. If I may, my lord, the portion. As well as for the provisions of the Arunachal Pradesh Scheduled Tribe Certificate Issuance Guidelines 2022, notified by notification dated so and so, an inquiry was conducted by the verification board to verify the authenticity of the claim based on inputs received from the field verification official inquiry and documentary evidence. And whereas the inquiry has revealed that Shri so and so, the petitioner number 1, my lord, is the biological son of Sri so and so, a non-tribal individual who does not belong to any scheduled tribe notified in Arunachal Pradesh, and that the individual had falsely declared his maternal grandfather Sri so and so as his father in order to project tribal lineage. And whereas it is a settled norm under the prevailing law and tribal customs in Arunachal Pradesh that scheduled tribe status is transmitted exclusively through the paternal line, and the children born to non-tribal fathers and tribal mothers are not entitled to ST status regardless of the mother's background. So this is the reasoning given for cancelling of the impugn ST certificate.
So what is wrong in that?
My lord, we have taken 2 grounds for impugning this, challenging this order.
Yes.
The
Yes.
first ground is, my lord, that as for the direction of the Honorable Apex Court in Kumari Madhuri Patil, the determination of the tribal status of a person is the sole jurisdiction of the scrutiny committee of a concerned state. If I may,
You have a scrutiny committee in the state?
yes, ma'am. If my lord will kindly come to page number 82. This is the notification, ma'am.
Political Commissioner SJETA means?
My lord. Sajeta, you know,
Huh?
social justice part.
Social Justice Empowerment. SJE.
Empowerment and tribal affairs.
Okay, Social Justice Empowerment Tribal
Commissioner Law.
Member, then Law Judicial Commissioner Member, Associate Professor, Tribal, so and so. So this is the Constitution.
This is the constitution.
So
And this is
the determination has not been done by this committee.
no.
So that is why you have grievance.
First grievance is that, madam. This committee has not determined my tribal state.
Okay.
First. And secondly, my lord, but second grievance is that the issue of this tribal identity is a issue of fact. As held by the Honorable Supreme Court, my lord, in Ramdev by Davai, Nakai and state of Gujarat. Now, only by the sole reason that the person, the father, the biological father is a non-atheist, non-tribal, will not deprive the child, the offspring, if the mother, in a case of a marriage between a non-tribal and a tribal mother, the child, the offspring, will not be deprived of the tribal status if the child can show that he was born and brought up in that community, he was accepted as part of that community, and he had faced all the same disadvantages and everything.
Under what provision?
My lord, the judgment was not going to be for you. I mean,
Is there any provision as such to show that you are accepted by the community?
my lord, I may be allowed to read the judgment.
Don't read the entire judgment. Just show me the relevant portion.
Relevant portion. Para 43.
Which judgment you want to read?
Ramesh, Abhay, Nakai.
Huh?
Ramesh, Bhai, Abhay, I, Nakai.
Ramesh. Okay, Ramesh Bhai. Okay.
If my lord, kindly turn to page number 20,
No, paragraph number. Tell me first.
paragraph 43.
Paragraph 43.
Page number 2.
Yes.
If I may read now, no?
Hmm.
In view of the analysis of the earlier decisions and the decision made above, discussion made above, the legal position that seems to emerge is that in an inter-caste marriage or a marriage between a tribal and a non-tribal, the determination of the caste of the offspring is essentially a question of fact to be decided on the basis of the facts adduced in each case. The determination of caste of a person born of an inter-caste marriage or a marriage between a tribal and a non-tribal cannot be determined in complete disregard of attending facts of the case. In an inter-caste marriage or a marriage between a tribal and a non-tribal, there may be a presumption that the child has the caste of the father. The presumption may be stronger in the case where the inter-caste marriage or a marriage between a tribal and a non-tribal, the husband belongs to a forward caste. But by no means the presumption is conclusive or irrevocable, and it is open to the child of such marriage to lead evidence to show that he or she was brought up by the mother who belonged to the scheduled caste tribe, by virtue of being the son of a forward caste father. He did not have any advantages start in life, but on the contrary, suffered the deprivation in dignities, human dignities, and handicaps like any other member of the community to which his her mother belonged. Additionally, that he was also treated a member of the community to which her mother belonged, not only by that community, by people outside the community as well. Now, given my lord, what I'm trying to impress upon this on my lord is that the issue that whether the child has been accepted as part of the community, that was also to be determined by the inquiry committee that was constituted by the respondent number 4, my lord. And by the impugn order, my lord, if the impugn order is seen, it can be implied that, my lord, that they have made no determination in regards to whether this ratio, whether the child was part of the community or whether the child was accepted in the community. That was not to be decided. They had only one issue to be decided. They only decided one issue, that whether the biological father of the petitioner was a non-PST or not. That was the sole determination. But if my lord will see annexure 14, my lord, we have annexed a gift deed. This petitioner was having land at that place. No objection. Having land, he was given land, he was enjoying land, no objection, my lord. And even from paragraph 13, my lord, then we have showed this, we have annexed the school certificate, my lord, page number 83.
This matter will have to be examined. And as on today, I don't think it's possible. We'll need a response from the other side. All that we can do is issue notice at this stage.
We had a prayer regarding the
Interim will not be passed today.
because my lord,
We may issue notice at the most.
my lord, the impugn order. Now, my lord, I
See, Mr. Counsel, rightly or wrongly, I'm telling you why. Because paragraph 2 and paragraph 3 of the impugn order says that some verification was done. It's not that they simply declared it. So whether that verification was correct or not is an issue to be examined by this court. So pending such, I don't think there's any cause for any impugn order at this stage. At the most, I'll issue notice.
Also verification was done. We are not disputing that verification was not done. But the Kumari Madhavi Patil mandates that verification should be done by the scrutiny committee.
So that's what, that will have to be examined That straight away, we're not determining that
My
this was wrong and that has to be done.
lord, we have annexed the board proceeding orders.
You also have not been determined straight away like that, isn't it? Not cancelled straight away. They have determined that because they have formed some sort of a verification. So the respondents will have to be put to notice. This is what has happened. What are you to say?
In that regard, my lord, can you rely on the judgment by the Honorable our Guwahati High Court in similar circumstances? Similar circumstances. This is the judgment by the double bench, my lord. If I may, if my lord will kindly see
Para?
para 10, my lord, page number 4. Start from page number 4. Aru Nebu. Para 10, my lord.
Just a minute. Para 10.
10, page number 4.
It was remanded. Matter was remanded
Para 10.
to that committee.
In this case, my lord, the deputy commissioner, in similar circumstances, they have adjudicated upon the ST status of the petitioner, but the same was set aside because the adjudication needs to be done by the petitioner.
That's what I'm saying. It was remanded back to the committee to decide. You want that today?
If it can be done, if the orders can be set aside and if it can be remanded back, then order.
Mr. Nawam, what do you say? Should we remand it back or you want to take instructions?
Before that, my lord. Now, seems to be very small, my lord. Otherwise, my submission is my lord, is a bomb. Well, it's a dangerous bomb, my lord. If it is trigger up, I am free. My apprehension is that it should be next to Manipur. Next to Manipur. Why I'm saying, now, my lord, this posting issue is the one of the burning issue that is happening. This posting issue. Now, so far, my lord, in this case, biological father is not disputed. What is disputed is the procedural license based on the Madhuri Padre, my lord. Now, as per the Madhuri Padre, my friend is very aware, my lord. The competent authority is the my lord, social justice. Why they have not raised any application to the Secretary, my lord, social justice, saying that the deputy commissioner is not a competent authority. There must be a committee in view of the Madhuri Party, and matter should be referred to your this screening committee. They have not said so. Yesterday they have come before your lordship. Now, my lord, what my friend is asking for, my lord, to state the my lord impugning order. If your lordship state the impugning order, that tender must be permanent, my lord. What do you call the prayer made by the petitioner? The lordship sees the prayer, my lord. Exactly, the interim order will be to that effect, my lord.
The interim order will overreach the main prayer.
Yes,
That's what I'm saying.
absolutely.
So
So
that's
at
fine.
this stage, my lord, let notice may be issued, or my lord, or matter can be referred to the screening committee. I don't
fine.
have any objection.
Okay.
Now, my lord, enter whatever exercise carried out by the district administration, that can be forwarded to the screening committee. And further taken.
If you agreed, we'll do that. Because end of the day, whatever instructions you come,
Ultimately, that has to be
if that
done.
committee is formed for that specific purpose,
Yes.
then ultimately I think that would be the order to be passed after in future.
Exactly.
So why not pass now? All right. Then, but that in that case, we'll have to interfere with the cancellation.
No, my lord, without interfering with the cancellation, the lordship may direct the deputy commissioner, what about the material they have, my lord, acquired, my lord, in lieu of, my lord, preliminary inquiry, police inquiry, whatsoever.
Okay, the order of the impugn order shall abide by the decision to be taken by the commission.
Screening committee, absolutely.
Okay,
That can be.
dispose it of then.
We may be protecting some kind of because
What
after,
protection? No, you have to be determined first. The council.
that's why my lord, after 46 years, they are suddenly saying I'm not an ST. So now I lost my every identity. I have been in that place for 46 years. Now suddenly
See, you can't have both the cake and eat it.
you know,
If you agree, we dispose it of, otherwise I issue notice and keep the matter pending.
my only prayer being that till the determining
No, no.
by the disciplinary committee, the order may be.
Your prayer is rejected, Mr. Council. We'll refer it to the commission. They will do it as expeditious as possible, as per the procedure which you have just shown, the highlighted regarding the decision of the apex court. And whatever decision they are to be taken shall abide, this impugn order shall abide by the decision to be taken by the commission. Okay.
I will be rendered then, still then time.
Maybe. This is a sensitive issue, Mr. Council. You cannot just pray like that.
Maybe. Some kind of, at least.
You are seeking, but court is not giving you that.
My lord, a
The council.
small time frame may be given until that period, at least, because ultimately, my lord, if the ST committee decides that I am not an ST, my ST certificate will go. But if they decide that till then I will have no remedy, I will be remedialess till they decide. If they take 6 months, 7 months, a year, I will be totally remedial.
Okay, please write down. Heart, Mr. You are Mr. G. Talo, Learned Counsel for the petitioner, as well as Mr. R.H. Nawam, Learned Additional Advocate General for the state of Arunachal Pradesh. Stop having regard to the projection made by the petitioners, and as agreed to by the parties, the matter is taken up for disposal at this stage, at the motion stage itself. Next para, by filing this writ petition, the 6 writ petitioners have projected their grievance against the orders the same date?
Same.
Orders against the orders all dated 8/5/2025, by which their respective scheduled tribe certificate has been cancelled by the Deputy Commissioner, Siang District, Koleng. Bracket respondent number
4.
Stop. It is the case of the petitioner that although their father are non-tribal, but their mothers are belong to the scheduled tribe of the state. Stop. Since they have been brought up within the tribal community within the state, they are eligible to be declared as a scheduled tribe. Stop. It is the further case of the petitioners that the Deputy Commissioner does not have the authority to interfere with the scheduled tribe certificate granted to the petitioners, in view of the fact that a specific committee has been constituted by the state government in the Department of Social Justice and Empowerment and Tribal Affairs. White order dated 26/6/2018, which is in pursuant to the directives of the apex court dated 2/9/1994 in SLP C number 14767 of 1993, open bracket, Kumari Madhuri Patil and others versus Additional Commissioner for Tribal Development, Maharashtra, close bracket, page 82, from it, 82. The Learned Counsel for the petitioners therefore submits that the impugn orders all dated 8/5/2025 should be set aside. So the Learned Counsel, in support of his submission, has produced the following authorities on dash. Number 1, Ramesh Bhai Dabhai Naika versus State of Gujarat and others. Three SEC 100. Number 2, Kumari Madhuri Patil and another versus Additional Commissioner, Tribal Development and others. 1994, 6 SEC 241. And the division bench judgment of this court in Arup Megu versus State of Arunachal Pradesh. (2020) Supreme bracket GAU 354. Next para, Mr. Arish Nabam, Garnet Additional Advocate General, submits that the petitioners have not disputed the fact that their respective fathers are non-tribal. And if the grievance of the petitioners are to be accepted, it was incumbent upon them to have approached the committee considered for the purpose.
No, my lord. First, they have to approach the nodal department, that is the social justice department.
Incumbent for them to approach the nodal department, that is the Department of Social Justice and Empowerment and Tribal Affairs. Bracket respondent number 2. Stop. Instead of taking such steps, the petitioners have directly come before this court. And having regard to the sensitivity of the issue, the writ petition cannot be entertained in the manner they have projected. The petitioners have projected. Stop. He, however, submits that there is a constituted committee to examine such kind of claim, and under the circumstance, court may consider and pass appropriate orders as it deems fit and proper. Next para. Having heard the learned counsels for the parties, and having regard to the fact that a committee has been constituted in terms of the apex court judgment in Kumari Madhuri Patil Supra by order dated 26/6/2018. He will file an application before the authority. In
Court proceeding, after that has come in before the committee court determined.
No, what proceeding?
This proceeding that they have concluded without bringing them on. Actually, my lord, these villagers, people of villagers are complaining. Now, when this complaint was taken up and someone made issue, now the verification part, that determination of the tribal identity, that part should have been remanded to the committee for determination. And then after their determination, based on their determination, the order should have been passed. Whether
Please, right? Okay. What did I say? Last line. Having regard to the fact that the committee then Is Commissioner political? This is a post. The composition of the committee. Commissioner political. They are not the respondent here.
But they are responding. The committee has been made a respondent. Respondent number 3. Madam.
Mhm.
The respondent number 3. The committee has been made a respondent.
The petitioners. You want to file an application. Within how much time will you file? 1 week? 1 week? 2 weeks. The petitioners within 2 weeks from today shall submit their respective application with their claim as regards their scheduled tribe status, along with a certified copy of this order before the respondent number 3. Stop. The respondent number 3, upon receipt of the same, shall give the petitioners an opportunity of hearing and thereafter take a decision in accordance with law. Stop. The committee will be at liberty to call for the proceedings of the inquiry, which is said to have been conducted by the respondent number 4. Stop. The entire exercise be carried out as expeditiously as possible and preferably within a period of 2 months.
Once, Madam, that would be best, Madam. Please
Why?
3 months, Madam.
Why? Is it a cumbersome process?
My lord, suppose if it's been the committee, if not satisfied with the conduct of the commissioner, the board proceeding inquiry, and then he will direct for doing the same exercise.
So definitely that they'll have to do their independent exercise. Only I'm saying that whatever materials is there, they will look at that, and if not satisfied, they'll also go further.
Correct. Only supplement.
3 months. Within a period of 3 months from the date of receipt of the representations from the petitioners. It is further provided that herein that the decision to be taken by the Procedural Committee, provided herein that the impugned orders dated 8/5/2025 shall abide by the decision to be taken by the screening committee. With the above observation and directions, the writ petition stands disposed of.
It will be because the order also is standing.
Huh?
No. Screen the committee order supersede, Madam.
Till
It will be superseded by the whatever decision to be taken. Okay.
till that time, I don't think.
No.
But
Item number 4.
Yes, Your Lordship. Before my Lordship, I start, I have detected some error here. It seems, Lordship, I have erased the wrong respondent because it seems NHIDCL, but I have impleted the Director General Border also. I think I'll need to make corrections, Lordship.
You file an application. Or you would want to withdraw and file afresh?
Lordship, I'll withdraw and file afresh.
Okay, as paid for by Mr. N. Tamgit, learned counsel for the petitioner. Writ petition stands disposed of as withdrawn with liberty to file afresh.
I'm sorry, Lordship.
It's okay. Ms. N. Ratan, learned additional advocate general, appears for the state respondents. As well as Mr. So-and-so, learned DSGI, appears for the Respondent Union of India. M. Kato, M. Kato.
Item number 5.
My Lord, in paragraph 16, I have stated that my elder brother on my behalf tried to submit a representative with the learned PFO refused to accept, my Lord. That part, my Lord, again, that has been accepted. So we are here now with the accepted. So on.
So what will happen to your paragraph 16 then?
My Lord, actually, when we applied, my Lord, it was, status was like that, but only when it was accepted there. That's why, it was Your Honor,
What is the case?
This is my Lord, eviction without affording opportunity. Your Lordship, this a case by agent of the present situation, present village has already been filed before this honorable court, and one order is here, passed by this honorable court, my Lord. But petitioner is also here, my Lord. So just to understand the case, my Lord, yes, my Lord, I will take your Lordship to case number 31, my Lord. Case number 31. It was passed in July or June 2015, my Lord. June 2015. By filing this writ petition, the petitioners have prayed for a direction to the respondent authorities, particularly the Department of Forest, Government of Arunachal Pradesh, to issue no objection certificate for creation of proposed Jipu Dodi as census village within the Tikpa Reserve Forest in the district of Lower Siang, Arunachal Pradesh. The petitioner claimed to be displaced person of all Dipu village situated within the reserve forest area due to plus growth had to be shifted to Jipu Dodi area of Tikpa Forest Reserve Forest. The petitioners also prayed for providing the rights and benefit under the Scheduled Tribe and other traditional forest dwellers recognition of Right Act 2006. Notice issued returnable in 4 weeks. Mr. Estapil, learned senior government advocate Arunachal Pradesh, appears and accept notice on behalf of all the respondents. No normal notice needs to be served. However, requisite extra copies be furnished to be as a learned state council. Considering that the petitioners are settled in the proposed Jipu Dodi village within the Tikpa Reserve Forest, and of course, after being displaced due to place growth from all Jipu villages situated within the said reserve forest and continue to be living since 2015, the status quo as of today shall be maintained till the return of the
I've read it. Well, how many writ petitions have you filed earlier? This is the third.
My Lord,
This is the third.
yes, my
Second time there was a status quo,
status quo, my Lord.
but maintainability was kept open
Yes, 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 okay.
because that liberty was not sought by you.
My Lord. No.
Now,
This liberty was not sought. Yes, liberty was not sought by.
this is what the order says.
And this hearing is yet to be there, my Lord.
No. All these 3 writ petitions are on the same cause of action.
That will have to be taken up later, my Lord. Because first thing, my Lord, that the 2000 writ petition was for eviction order, my Lord. Number 1. Now, this is not for eviction order, this writ petition 287, that status quo has been passed. Just we have visited here.
287 is for
287 is for grant of NOC, my Lord.
NOC.
Yes, my Lord. Prayer has been, I have laid out the prayers here, page number 11, my Lord. Page number 11 of my writ petition, my Lord. Present writ petition. I have just throw out this prayer that they have made in this 287 writ petition, my Lord. 11, my Lord. Page 11. May I read?
No, in the order itself, it's written, page 31. The petitioners have prayed for providing rights, privileges, and benefits under the ST
My Lord.
and other traditional forest dwellers recognition.
My Lord, yes, my Lord. Yes. Now,
This is your prayer.
yes, my Lord. And 2017 was
Now,
an action initiated
for
against
eviction.
eviction, my lord.
And today, what is this for?
It is for another eviction, my lord.
See, again, another eviction.
It is another eviction, my lord. May I come?
What happened to the first writ petition?
First writ petition, they have been assured, okay, you don't cause any destruction and damage in the forest.
First writ petition
Yes.
was disposed of.
Disposed of.
As not pressed.
No. Accordingly, they have withdrawn, my lord.
You have withdrawn
Yes, we have withdrawn. My lord.
without liberty.
Without liberty, because there was in discussion, there was an assurance that they will not be, they should not further the occupation and cause destruction in the reserve forest.
Okay, anyway, now this is a fresh eviction.
Yes, it
This
is
is a-
fresh eviction.
A fresh eviction.
Yes, fresh eviction. And may I read it, my lord?
Page number?
Page number 33, my lord. Page number 33. And from the content itself, your lordship will have the idea of the previous action of 2017, my lord. May I
Please read. Please read.
Whereas a case of offense for encroachment of the forest reserve at Gogar area has been booked against you and forwarded to the Honorable Court of Chief Judicial Magistrate CGM Alo, West Siang District 85, number this dated 14/12/2017, my lord. This was the issue, my lord. It was in Gogar area, my lord. The matter is sub judice pending in the court, where status quo is to be maintained till the final verdict of the court, my lord.
That is that writ petition.
It was withdrawn. This issue was withdrawn, and it has been matter has been kept there, placed in this CJM alone.
No. Which matter was withdrawn?
No, this eviction connected to this case.
No, the status quo mentioned here in this impugn order
Well,
is regarding WPC 287.
no.
Which case then?
They have said he has instructed that you should get it maintained status quo till the finalization of the case pending in the CGM alone.
There's another case pending.
Pending, that is, yes, it is regarding Gogar, my lord. It was Gogar. They requested us to
Matter is sub judice and pending in the court where status quo is to be maintained till final verdict of the court.
my lord.
This refers to the CGM case in the CGM court.
My
Okay.
lord, my lord.
Okay, then.
Whereas you have unauthorizedly occupied a part of Dipa Reserve area under Likapalli Forest range of Likapalli Forest Division and have unauthorizedly constructing a permanent concrete structure there. Whereas your act is violation of section 24B, section this under Assam Forest Regulation 1890. As per Arunachal Pradesh, ejectment of authorized person from reserve forest, besides other action are prepared as per prevailing law and is offense and makes you liable for ejectment from the said portion of reserve forest area. Therefore, the undersigned as per the powers vested in him under forest, Arunachal Pradesh Forest ejectment of unauthorized person from Reserve Forest Rule 2013, direct you to vacate the RF within 15 days, failing which necessary eviction as per the provision of law will be carried out in the area. Your Lordship, if we visit this Arunachal Pradesh Forest Rule 2013, my lord, is posted in page number 34, my lord. It says opportunity of being heard should be given to me.
Where? Which rule?
My lord, page number 34.
Rule number
Rule number 3, 2, my lord.
32.
My lord.
Read.
If the sub-regional forest officer is of the opinion that any person with an unauthorized occupation of land in the reserve forest should be evicted, the divisional forest officer shall issue in the manner herein prescribed a notice in writing calling upon all persons concerned, that is to say, all persons who are or may be in occupation of or claim interest in such parcel of land, to so cause by an order of eviction of ejection shall not be made. Notice shall specify the ground on which the ground order of eviction is proposed to be made. Require all persons concerned, that is to say, all persons who are or may be in occupation or claim interest in such parcel of land, therefore, so called if any against proposed order,
Okay, anyway,
my lord,
you are governed by these rules.
my lord,
Arunachal Pradesh ejectment of unauthorized persons from reserve forest.
my lord,
Rules 2013.
my lord.
This is framed under some act.
Yes, my lord. It is under this. My lord, Assam Forest Rules, my lord. Rule 72, my lord. Right, well, section 72, my lord.
Regulation.
Regulation, my lord.
In exercise of the powers conferred by subsection C of section 72 of the Assam Forest Regulation.
My lord,
So under the regulation, the rules have been framed.
my lord, your lord,
And the rule 3(2) provides for a notice
my lord,
and the manner in which notice is to be served.
my lord.
Yes, government, what you say?
It's
Notice not given?
this notice,
Hmm?
page 33.
33 is a notice.
This is not because
But it says you will be evicted within 15 days.
in region also lordship can see that this another constructing permanent concrete structure also. Yeah.
Okay, but the notice means you have to give opportunity of hearing to the other side. Let them file some response or you give them a hearing. Then you pass the order of eviction as prescribed by the rules.
See, basically also this of this court or that or that.
Yes,
Status quo was given.
yes.
Status quo applies to both the parties. But here status quo was
Now status quo is given, then this writ petition disposed of already. Or is it pending?
this one, not the one
Pending.
Pending.
next year. This is the recent one also. Order that is 2025.
Correct.
Yes, sir.
What was the prayer there?
Here status quo has been given.
No, what was the prayer? It is not regarding eviction. But this is for giving no objection
My lord,
NOC.
or creation of proposed Jipu Robi as census village within the. They want NOC. So court says that the status quo be maintained.
your lord,
No, what is the requirement for having status quo in that case?
my lord, your lordship,
What is the requirement?
your lordship. In fact, they were disturbing some of the villagers there, my lord. This petition,
They were?
disturbing some of the villagers, my lord. That's why we told them, submitted before this honorable court, that we are not outsiders. We are born and brought up in this forest reserve. And our villages, where this traditional villages existed much prior to the notification of the DIPA Forest Reserve, my lord. DIPA Forest Reserve.
No, you were disturbed by others.
No, by them, by the department. Department of Tourism, my lord. Your lord.
Department was trying to do what?
Let me throw a very big, like only issue. We were staying there since 1964. DIPA Reserve Forest was established, notified in 1970, my lord. And in 2010 and 2012, my lord, 2012, my lord, 2014, this very dangerous place plot was out our village, Jipu village, my lord.
Dangerous what?
Place plot, my lord.
Flash.
Plot,
Flood.
place plot, yes, my lord. That was out our village, my lord. So, department, district administration took a stock of the situation, and they have declared our village danger zone, my lord. And we were directed by the department to sit somewhere, my lord, separate. My lord, that is in page number, my lord.
Jipu Dodi area
Oh, yes, Jipudodi area. We
of Deepa Reserve Forest.
yes, both are in,
You were allowed to shift there
my lord,
and
by the administration. But this forest reserve, forest people say you cannot go there. Whereas we are not coming from outside, my lord. Please go to
no, see, after you shifted to that area, you are demanding that you should be given NOC
and also,
for creation of a proposed Jipu Dodi
My lord, my
as
lord.
a census
My,
village.
yes, my lord. Yes,
As a census village.
yes, it was also not
Since
necessary.
it was not given to you,
Yes, my
you filed this writ petition.
yes, my lord. My lord, in fact, it is,
And status quo order given by the court is for you to remain there,
yes, my lord.
isn't it?
Remain there, my lord.
Now eviction has come.
Eviction has come, my lord.
So when status quo is on, why eviction?
My lord, that is also a question, my lord.
Mr. Day?
and-
And this writ petition is still pending as on today.
yes, my lord, pending.
We'll club it together.
Okay, my lord.
Yes, Lord.
The status quo will continue in this house.
Okay, my lord.
You heard, Mr.
E. Jammu, my lord.
E. Jammu, learned counsel for the petitioners, submits that petitioner
Petitioner, single petitioner, my lord.
who submits that the petitioner is aggrieved with the notice dated 8/9/2025, bracket annexure Roman 4, by which
Not second. Noted that he is the only petitioner here. He was given notice because he is the only one who is doing the concrete construction. In that, it's disputed now, Lord. He should not be constructing. Yes. They have
okay, what
said
did they
that
say?
clearly, Lord.
What is,
Unauthorized constructing. Permanent that.
he has been directed to vacate the reserve forest area within 15 days, and failing which necessary eviction as per the provisions of law shall be carried out. Stop. The learned counsel for the petitioner submits that the petitioner has not been given a notice prior to issuance of the impugn order as mandated by the Arunachal Pradesh Forest, open bracket, ejectment of unauthorized persons from reserve forest, close bracket, rules, 2013, which has been framed of Assam Forest Regulation, bracket 7 of 1891, close bracket, as applied to the state of Arunachal Pradesh. Stop. The learned counsel further submits that the petitioner, along with others, have also filed WPC number 287 of 2025 before this court. Seeking a direction to the respondent authorities concerned for issuance of no objection certificate, creation of the proposed Jipu Dodi as census village within the Deepa Reserve Forest in the district of Lower Siang in Arunachal Pradesh. Page 31, from there you get dates. Stop. The learned counsel submits that this court-wide order dated 27/6/2025 has directed the parties to maintain status quo. And the writ petition is pending as on date. So in the meantime, the petitioner has been issued the impugn ejectment notice. Next, madam. Ms. G. Ade, learned additional senior government advocate, submits that as per the said order dated 27/6/2025, the court had observed that the parties shall not cause any damage to the environment and ecology of the forest area. And that their settlement in the reserve forest is only on temporary basis. Stop. However, the instant petitioner has constructed a permanent concrete structure unauthorizedly. And it was on that account that the ejectment notice has been issued. Next paragraph. Be that as it may, let notice of motion be issued, turnable by 4 weeks. Ms. G. Ade, Learned Additional Senior Governor, it accepts notice on behalf of all the respondents. And therefore, no formal notice is required. Stop. Petitioner shall, however, furnish requisite copies of the writ petition to Learned State Council within the course of the day, within 2 days, within 2 working days. Next paragraph. Having regard to the fact that the prior notice had not been issued to the petitioner in terms of the rules of 2013. Earlier, I given you rules, bracket. In terms of rules of 2013, the impugn notice dated 8/9/2025 shall remain state till the next returnable date. Stop. The petitioner on his part shall also not engage himself in further construction in the land occupied by him. List again after 4 weeks.
Much obliged.
What to do with this?
My lord, we will file it in this additional.
One more line. Liberty is also granted to the petitioner to file an additional affidavit incorporating the subsequent development. If so advised.
Item number 6.
Yes. What is this matter? There's a caveat also. You're the caveat.
Yes.
What is the matter?
This is related to Racing Hydro project, electric project at Lepure, Papumpare district. So, Lord Chief, the brief of the case, the petitioners are the villagers, petitioner are the villagers under, polling under Panchayat, Pape Panchayat, Lepureng Circle. And within their territorial jurisdiction of Pape Panchayat, one dam project is coming up, or dam project has come up. So these petitioners are challenging, opposing the very construction of that dam due to omission of their names and their names from the property rights. Rather, their lands has been showing some other village properties. So in this regard, they have submitted so many representation from circle level officer to district level officer. All
What is being constructed? Something?
12 megawatt hydroelectrical project
Where?
at Racing village
Rushing?
under Lepureng Circle under Papumpare, Arunachal Pradesh.
You have provided some synopsis in your application.
Yes. May I read, Your Honor? The present petition arises out of
No, just a minute. Let me find out your synopsis first before you read. We can read together. Yes. You may read.
the present petition arises out of illegal and arbitrary orders of respondent authorities in permitting the construction of 12 megawatt Racing hydroelectric project at Racing village, Lepureng Circle, Sagali, Papumpare district, Arunachal Pradesh. That the government of Arunachal Pradesh through its cabinet decision dated 22/9/2017, number so and so dated 19/12/2017 allotted the same project to developer MS Yekung and later changed to MS Yekam Power Private Limited under agreed term to constitute special purpose vehicle. The developer later with malign intent has misrepresented the project area as being confined to Racing Village, the native home of the developer. Whereas in fact, the project directly falls under the lands and properties of petitioners and villages, namely Sango 1, Sango 2, Lower Sango, Bikur, Butso, and falling under the Pape Panchayat under Leporing Circle, Sagali, Papumpare District, Arunachal Pradesh. By suppressing these facts and in purported compliance with the provision of Forest Conservation Act 1980, Scheduled Tribes and other traditional forest developers, recognition of Forest Right Act 2006 and Rules 2017, Rule 2007 and notification passed by Minister of Tribal Affairs, Government of India, the private respondent in his writ petition obtained a no objection certificate from the Gram Sabha of Leporing Panchayat. As Racing Village comes within the jurisdiction of Leporing Panchayat and deliberately avoided seeking consent from the Gram Sabha of Pape Panchayat, whose villagers are substantially affected. Repeated representation by petitioners and agreed villagers to the circle officer Leporing, Additional Deputy Commissioner Sagali and Deputy Commissioner UP and other authorities went unheeded, compelling the petitioner to approach this honorable court by filing two petitions registered as WPC 534/2023 and WPC 45/2023. This honorable court, while its order dated 15/11/2023 in WPC number 534/2023, had directed the Deputy Commissioner to resolve the matter through local NIL, customary settlement. However, in deliberate defense, the Deputy Commissioner acted on its own and issued orders in favor of project developer. They were frustrating the intent of court's order. Subsequently, the petitioner approached the Honorable Deputy Chief Minister, Government of Arunachal Pradesh, through representation dated 23/7/2025, pursuant to which Under Secretary Hydro, through its letter number so and so dated 4/8/2025, directed the Deputy Commissioner UPA to stop the project and comply with the Honorable High Court's order. Shockingly, Deputy Commissioner passed an impugned order number so and so dated 18/8/2025, contrary and non-complying the Undersecretary direction, and allowed the developer to continue with the construction activities through the process of land, though the process of land acquisition is admittedly incomplete. In parallel, the Forest Department arbitrarily declared the petitioner community land as an unclassified state forest land of Racing Village without any documents and records, thereby further infringing upon traditional and ancestral lands of the petitioner. The act of respondent authorities are ex specie arbitrary, malified, and gross violation of Article so and so in this petition.
So what has happened to the two writ petitions? They have been disposed 534
534,
disposed.
no, it has been disposed with the direction to conduct a NIL meeting.
Disposed of. Mail was conducted? No,
Mail was not conducted.
not conducted.
No, mail was not conducted, but we see its own due course. He has made
Okay.
subsequent orders.
Okay, then WPC 45
45, it has been withdrawn with the liberty to file
draws. So this is the only writ petition now.
Yes.
Now in this writ petition, what have you challenged?
So in this writ petition, I am challenging specifically. My grievance is that when Government of Arunachal Pradesh has issued the latest direction by the Secretary Hydro, then why this Deputy Commissioner UPA is not complying with the order?
Can you approach the government
Yes,
and say why the deputy commissioner is complying?
but yes. So that's why, because
Why should we execute the government's order?
no,
Not
one,
being complied by
not only your lordship, not only this ground. There are several grounds. Second ground is that deputy this one.
No, any particular order you have challenged here?
Yes.
Any particular order? Is it the order of the deputy commissioner?
Yes. All orders are passed from deputy commissioner. In page number 26, para 1.
No, show me the annexure.
No, not annexure.
You're not annexed.
In petition.
You're not annexed.
No, oh, that annexure I have annexed.
What is there? What are the annexure numbers?
Annexure 1, page 78. Page 78. August 2025.
Please read. What does it say?
Whereas order, whereas a government direction dated so and so 4/8/2025 issued to understand wherein government has directed that no further action including compensation, disbursement or construction is to be undertaken at Racing Hydroelectric project site until compliance with Honorable High Court direction in the matter of WPC 534/2023 dated 15/11/2020. And whereas in compliance with Honorable Guwahati High Court, the Deputy Commissioner has already passed an order wide so and so dated 4 December 2023, which clearly states that out of total land required for project development, 12 megawatt Racing Hydroelectric project, only 1200 square meters or 600 square meters at the intake point is disputed. So the relevant second last para, and whereas DC Pakumpare wide so and so dated 4th March 2024 conducted a hearing with the petitioner on 23/2/2024 and consequently upheld the office order number so and so on 4th December 2023. So in a view of above, I do hereby direct that non-activities of any kind shall be carried out by MS Gaping Power Private Limited in a disputed 600 square meter area within Racing Hydroelectric project site under Neighboring Circle of Pakumpara until further order. This is the past in order. And this order was issued, passed in violation of the Honorable High Court order and recent Honorable Secretary Government of Arunachal Pradesh order.
So how are you aggrieved by this order? It says no activities of any kind shall be carried out by the MS Gaping Power Limited in the disputed 600 square meters within Racing Hydroelectric project under so and so further orders. How are you?
Here, Lordship, here the very interesting things come. Actually, petitioners are claiming 23,300 square meters of land, which comprises of 80% of the project required land. But they knew that these petitioners are objecting to them before the issuance of any public notice by the authorities. So they have manipulated this by showing the land, their land, as a land of the neighboring village. The neighboring village is the village of the developer.
Racing.
Racing, yes. And it is a village of the developer. So we have been, before any public notice was issued, we have been filing objection against objection, but no use. But initially Circle Officer Le Pore has issued a notice to the petitioner.
What is your
Conduct
objection?
of mail.
Show me one of your objections regarding your land, 80% of the land being used for this hydroelectric project, whereas it is shown as Racing, within Racing so and so.
Your Honor, your Lordship may look page 338. It's a land requirement shown by land requirement prepared by the project developer MS Gaping. So
now who's the developer? Gaping.
yes, MS Gaping.
So Gaping has been prohibited from making any development.
No. The works are going on, still going on.
But here order says direct that no activities of any kind shall be carried out by MS GECAM.
Only under 600. Only under 600 square meter also. And very interesting, this project has not final, no compensation, nothing has been done, but work is going on
So how
in war putting.
how do you determine 600 square meters area?
No, for me, Your Lordship,
No, is it demarcated? How do we know 600 square meters within?
no,
The-
this is our travel line. This is our travel lane. We are not only determining the 600, we are claiming whole 23,000 square meters of.
No, I understand that. As per this order, it says that no development should be done within that 600 meters. So where is that 600? Where is it defined that these are the 600 meters area?
That is intake point. Intake point of the project. Page number 338. Its location it is given forest land 0.6 600, that is. Page number 338.
Where in 338?
Right side. Most right side. Forest land in hectares, forest land in square meters, 600. That is that comprises of trench wear on river bed. Serial number under component serial number 1, trench wear on river bed.
This comprises of 600 plus other lands are there.
Yes, other lands are 600 is the disputed which the DC has shown in the order. And this order is a very similar order of earlier orders passed by the Office of Deputy Commissioner. So there is no change in any orders. Same orders we give several representation, but orders comes in one way. And our petition is not been genuinely heard. Since from 5 years we have been wandering from pillar to post, protesting and uprising before the authorities. At last, and our villagers are being getting arrested on course of protesting against this project construction.
The council, the project is 12 megawatt Racing Hydroelectric project, isn't it?
Yes, that's it.
Now, this comprises of what is that? Racing village. And also villages including Sango, Wat 2, Lower Siang, Bikul, Butso, falling under the Pape Panchayat. Covers all these lands. And developer has confined the work only for racing village. Although he's utilizing the entire area, but he's projecting that this only is
The land comes under racing.
land comes on under this. So basically the dispute is regarding the area of operation. Because the land, according to you, covers a vast area, including your land, not only racing village, but entire area. But developer is saying that it's only regarding racing village.
So
That much I've understood. And beyond that, what is this Deputy Commissioner's order saying that the developer, the GECOM is a developer, isn't it?
yes, yes, sir.
He will not carry out any work within the disputed 600 square meters. So according to the Deputy Commissioner, only that 600 square meters area is disputed. Remaining portion is not disputed.
Yes.
Otherwise, you are saying that the entire area is disputed.
No, no. We are claiming, we are asserting to the, we have submitted several representations to authorities claiming that 23,000, the 80% of the project is our land. We have been thrown away. We just like we are being thrown away, and fraudulently they are showing due to economic and political social stature of the private developer, the respondent number 12. They have manipulated with the government officials and they have got all this clearance. But before any clearance, before any notices was issued, we were objecting the same. We assumed and we came to know that some sort of projects is coming up in our village, but this our project, our village is not being included. Initially, the Deputy Commissioner UPIA and concerned circle officer accepted, taken our consideration and issued a public notice to our village also and to held the Gram Sabha also. But later on, I don't know what happened. They all changed. All documents came in a form of showing that our land as a racing land. So this is the core of the issue. So we are here. Our land is going out. Our tribal right is going out. Our forest, everything is there. And in this petition, no panchayat was informed. As per the law, panchayat should be informed.
The petitioners are from which village?
Pape panchayat villages. Pape panchayat villages.
Only?
Yes. Pape panchayat comprises of 5 to 6 villages.
Okay, that is Sango 1, Sango 2, Lower Sango, Bikul, Butso. All these. They come under the Pape Panchayat.
Yes, sir.
So how have you approached the authorities? This is what I want to know.
Yeah, we have approached the authority.
How? Show me a document. You have the next some memorandum of agreement. This is between whom? Mr. Council, you do one thing, you prepare some concise list of dates for the court to, so that we can understand.
Yes, sir.
Okay, and submit that, take it up again on Monday. Please write the petitioner shall prepare the concise list of dates to enable the court to appreciate the facts of the case and the kind of relief being sought for. This is the matter again. Monday.
In page number 81, 81, 82, I have submitted so many representations to DC. Yeah.
You make a list of dates. Okay. Monday. Lovely.
May it please your lordship. Sorry.
Okay.
May it please your lordship.
Yes.
Lordship, this matter pertains to filling up of the posts of Assistant Project Officer RE in the DRDA. The DRDA has been taken over, my lord, has been disbanded and, my lord, merged with the Department of Rural Development, my lord, in the government of Arunachal Pradesh. My lord, there was a notification, if my lord comes to page 87,
The RD has merged with RD.
RD, Department of, it has been disbanded, my lord, disbanded
Now
and
it's
merged.
RD.
RD, my lord.
Okay.
If my lord comes to page 87,
Yes. 87.
87, my lord, this is a notification of 22nd February 2024, my lord, in which the persons manning the post in the DRDA, they have been taken over in corresponding posts in the Rural Development Department, my lord. If my lord comes to page 89, my lord, serial number 63, 64, and 74. These are the petitioners, my lord. We had been, my lord, absorbed as APO RE, that is the Assistant Project Officer, Rural Engineering in the erstwhile DRDA, and, my lord, thereafter in the Department of Rural Development. Now, my lord,
Just a minute, Mr.
my lord,
63.
64 and 74, my lord.
What's the serial number?
Serial number, my lord.
63 is petitioner number.
Petitioner number 2, my lord. 64 is petitioner number 3, and 74 is petitioner number 1.
74.
74, my lord.
Okay.
All of them, my lord, have been absorbed in the Rural Development Department in the rank of APO RE.
What were they earlier?
Earlier, my lord, they were technical assistant, my lord.
Is it equivalent to APO?
No, my lord. My lord, the staffing pattern, there is no rule, my lord, in the Arunachal Pradesh, my lord, in the DRDA or in the government, my lord, but a staffing pattern was there earlier, my lord. If my lord comes to the annexure, my lord, at page 31, annexure 1, the relevant portion is at page 34, my lord.
Yes, 34.
Under the heading, my lord, wage employment wing, serial number Roman 4, my lord. My lord finds it.
Yes.
My
Yes.
lord, 1. The post of Assistant Project Officer Rural Engineering in the pay scale of so-and-so shall be manned by taking deputationists from the cadre of Extension Officer Rural Engineering of the Rural Development Department, having minimum service of 11 years in the grade of so-and-so, or 8 years in the grade of so-and-so, or 5 years in the grade of so-and-so, or failing above, direct recruitment may be done on contract basis with consolidated salary. The candidates shall possess minimum qualification of degree in civil engineering with field experience, if any. Then number 2, the posts of technical assistant IWDP in the pay scale of so-and-so and technical assistant RE shall be manned by deputationists drawn from the cadre of extension officer of Rural Development Department having minimum 5 years service in their grade, or failing above, direct recruitment so-and-so. So, my lord, assistant project officer are filled up from extension officer, but not directly from technical assistant. And the posts of technical assistant, my lord, are also filled up from extension officer, having a minimum 5 years service in that grade. Now, we had grievances.
Petitioners are
Technical.
working under the DRDA.
Yes, my lord, as technical
They're
assistant.
working under the DRDA
My lord.
as what?
Technical assistance. Earlier, my lord.
Technical assistance.
Technical assistance. But,
Then
my lord,
this post of technical assistant is equivalent to APO.
not equivalent, my lord, but it is directly not a feeder cadre to the post of APO, but the posts of technical assistants are filled up, my lord, from extension officer, which is the same feeder cadre for assistant project officer. However, my lord, they have to have minimum 5 years of service as extension officer to fill up the post of technical assistant. So therefore, my lord, technical assistants are superior to that of extension officer, though directly not a feeder cadre for assistant project officer. We had this grievance earlier, my lord. We had approached superior in rank to that of my lord, because the post of technical assistant is filled up from extension officer having minimum 5 years service.
Okay. Then
My lord, we had this grievance earlier that there was no promotional avenue for technical assistant to fill up the post of assistant project officer. We had come earlier before lordships, and we were directed, my lord, to file a representation. We had accordingly done so, and thereafter, my lord, if my lord comes to page 76.
76.
My lord, it's a typed copy. The photocopy is at page 75. My lord, may read the
Yes.
typed copy. My lord, it is in receipt of the above mentioned representation along with Honorable High Court's order dated so and so, whereby it is directed to dispose of their representation. The matter has been examined and found that the posts of TA, that is Technical Assistant RE and TA IWDP under DRDA autonomous body, are same status, and their qualification for recruitment is also the same. The recruitment rules for the posts have not been framed. Therefore, vacancies in the grade have so far been filled up on temporary basis. If any vacancy in the grade of APO RE occurs in future, possibility shall be explored for accommodation from the grade of TA IWDP and TA RE. This was the stand taken, and thereafter, my lord, we had been given the charge of APO RE. My lord, we were discharging as such. Thereafter, my lord, this gazette notification which lordship had read, absorbing on disbanding DRDA, absorbing the employees of DRDA in RD department, we were absorbed as APO RE in the rank of APOR. Now, my lord, the impugn notification, my lord, has come at page 102, my lord.
Yes, 102.
Yes, my lord, this is 1st of May 2025. The relevant, my lord, is at page 104.
Yes.
My lord, serial numbers 92 to 94. My lord, the earlier notification has been amended, and we have now been shown to be absorbed as TAIWDP. Petitioner number, at serial number 92 is petitioner number 3, serial number 93 is petitioner number 2, and serial number 94 is petitioner number 1. Therefore, we are aggrieved, my lord. What we are praying for, my lord, is for framing of the rules to fill up the posts. And, my lord, we are challenging this notification of 2025, my lord.
Framing of rules for what?
For filling up the posts of APO RE, since there are no rules in place. And in fact, my lord, we had obtained under RTI another document at page 124.
Yes.
Wherein they say this is a RTI reply, my lord. Total strength of APO RE so and so. There is no provision for regular appointment to the post of APO RE. Then serial number D. EORE are eligible for deputation to the post of APORE via government OM number so and so of 1998. There is no regular promotion has been made to the post of APORE. My lord, if there is no regular promotion which has been made, my lord, the other persons who have been shown absorbed as APORE in the 2024 notification, that is also not possible. We have been discriminated against, my lord. So therefore, we are before lordship.
Page?
Page number 104, serial number 57, serial number 66.
These are the petitioners.
These are the other persons who are shown as absorbed as APOR.
No, serial number?
57 to 65.
My lord.
57 to 65.
57 to 65. Page number 104.
Above us, my lord, in the page which lordship has seen, my lord.
They are absorbed as?
APOR. Sorry.
They were the deputy chiefs. They come as deputy. That deputy as EOR.
EORE is equivalent to APORE.
No, my lord. No, my lord. EORE is a feeder cadre.
So on what basis they have been
That is why we are
designated
before,
as?
that is why we are before lordships. We were similarly
What was their original post?
EORE, EO,
EORE.
EORE, and
Extension officer, RE means?
rural
RE means what?
rural,
Rural engineering.
my lord,
They were extension officers, rural engineering.
my lord, my lord.
Their substantive post.
Their substantive post.
Now they have been shown as APORE.
Yes, my lord. Yes, my lord.
So this is promotion by way of absorption.
My lord, they, yes, my lord. That is what they have done, my lord. My lord, there is another order from page 125. If my lord comes to page 131. We were all along in the DRDA department, my lord.
131.
131, my lord. It starts at page 125. The operative portion. Sorry, my lord. This is a order in WPC 105 of 2016. My lord may come to, sorry, my lord may come to page 130, para 6 of the judgment. This is.
Who are the petitioners? Who are the parties here?
The parties were some other persons who were holding the post of assistant project officer. Then they were sought to be repatriated. They had challenged their repatriation. They were extension officers. If my lord may come to, this is a judgment dated, my lord, 4/9/2019. As it was challenging,
Okay.
my lord. My lord may come to page 130, the operative portion.
APO post and EO post are the equivalent?
No, my lord. EPO is the feeder cadre. EPO with, sorry, my lord, EO with 12 years, 8 years, and 5 years experience, they can be filled up, they can fill up the post of APORE. Similarly, APORE. Similarly, my lord, sorry.
This writ petitioners at page 125,
my lord,
they were deputationists.
Yes. They were deputationists.
Now, on deputation, you can be posted to a higher rank.
Yes, my lord.
Isn't it? There's no issue about it.
Yes, my lord.
Only that you cannot be posted below your rank.
Exactly, my lord. Exactly.
At par your rank, or you can go high.
Yes,
so these people were posted as APRO.
APORE. There is no problem with that. But when they were sought to be repatriated, they had
Then
challenged.
they came.
Yes, my lord. My lord,
So what is the order then?
My lord may come to page 130, para 6 of the judgment.
Yes.
My lord, in view of the matter, the impugned order dated 19/2/2016, by which the petitioners have been repatriated to the post of extension officer RE, who were otherwise working as assistant project officer RE on deputation basis, could not have been issued on the basis of office memorandum dated 10/2/2016. Accordingly, the impugned order dated 19/2/2016, issued by the Commissioner RD and PR, Government of Arunachal Pradesh, wide number so and so, insofar as the petitioners are concerned, is hereby set aside and quashed, leaving it open to the respondent authorities to deal with the petitioners in the manner provided under the rules, insofar as deputationists are concerned. My lord, my lord.
Oh, what does it mean?
My lord, it means that they are deputationists. They have not been absorbed there. Since they are deputationists, they have to go back. We were not there before the Honorable Court in this set of petitions.
No, I understand. So the petitioners wanted to stay back as APRO.
Yes, my lord. But the court said they are deputationists. Their status is that of deputationists, and they have to be dealt with as such.
Then what about these impugned orders which has been set aside? What has been set aside?
That is the repatriation order, my lord.
Repatriation has been set aside.
Had been set aside and has been
repatriation set aside. At the same time, court has given liberty to proceed as per the rules for deputation.
So why I'm pointing
impugned order was repatriation, isn't it?
Yes, my lord. Impugned order.
If they are repatriated, what is wrong in that?
No, my lord, there is nothing wrong. What I wanted to point out before lordship is that their status, as recognized by this honorable court, is that of deputationist, my lord. Now, my lord,
petitioners, and who are these petitioners? They were RE.
They were
They were EO,
EORE, below us in part,
deputation as as APO.
APO, APORE. Now, my lord, all these persons, they have been absorbed as APORE via the impugn notification of 2025.
Otherwise, they are actually what?
EO.
EO.
EO, my lord.
And what about the petitioners? What are they?
We are TA, my lord, technical assistant.
TA.
Technical assistant.
TA is equal to EO?
No, my lord, it is
Yes.
superior in
Yes,
grade.
equal.
Huh?
Yes, equal. If pilot comes to case number 87,
No, before seeing any documents here, just ask me, just answer.
you
TA, technical assistant.
technically is that they are getting higher pay scale than you are.
TA is higher.
Yes.
Higher.
TA is higher.
Yes,
But
my lord.
now here is that case that EOs have been absorbed as APO.
APO. But we have not.
APO. You have not been absorbed.
We have not been absorbed as APO.
So absorption has happened on what basis? If there's no rules,
That is why we are before lordships, my lord. That is our prayer, my lord, that the direction may be given, my lord, to formulate the manner in which the absorption should be done. And, my lord, to set aside the impugn notifications. My lord, at this stage, my lord, a notice may go to the respondents, my lord. Perhaps, my lord.
straight away. But petitioners, as I understand, you all were the employees of DRTA.
Yes, my lord. We were
DRTA, you were working as TA.
TA, my lord.
TA is what? Technical assistant.
But we were functioning as APO.
APORE.
Yes.
Yes, my lord.
Since 2020.
Then
Extension was going on. We were functioning as APO.
you were functioning as APORE.
Yes.
You are.
Now, when DRT has merged with RT,
Yes.
then what have you become?
In the erstwhile notification, we were shown as APORE as absorbed. But by this APO notification, our names have been shown as EIW.
Okay, show me the erstwhile notification,
Page number 87.
which you had shown me.
2024, my lord.
2024.
Yes, that is the erstwhile. Page number 89
So
is the relevant.
it's a changed situation now.
Yes.
Earlier you were shown as APO,
Yes.
RE, now you are shown as,
Page number 89.
now you are shown as
TA.
TA.
In page number 89, serial number 63, 64.
But your substantive post is TA, isn't it?
Yes.
So how can you have that grievance?
So
If your
the
substantive,
section post, as per the RTI documents, is 16 in numbers.
sorry,
Is 16 in numbers.
which section?
Section post of APORE.
Okay,
So in 2024 notification, there were 16 APORs shown. Out of 16, the petitions are 3 in number. Now, in notification, the 13s are there. 13 APORs are there as absorbed APOR, but we were not.
13. One. These are 9.
We 3 are left out.
No, 657 to 65 is what? 9. 9.
My lord.
Where are the others?
Lordship, it's in other areas, APORE, monitoring, credit.
See, thing is that your substantive post is
TA.
TA, but you were given to charge of APO RE,
We were functioning, my lord.
functioning as APO RE under the DRTA.
My lord.
Now, once the DRTA merged with RT, when did it merge?
My lord, 2024, my lord. That first notification.
24.
The first notification.
And it's a 6.
Yes, my lord.
That time you were shown as APO.
Yes, my lord.
Now you have been shown as
TA.
TA,
While those who were,
which is your substantive post.
my lord, technical assistant.
Yeah, that's what you are the technical assistant in the,
Indeed.
as your substantive post.
Substantive posting, but functioning as APO. The other persons, my lord, their substantive posting is that of EO, but they have been absorbed as APO, as were we earlier. Now only we have been shown rather demoted to TA, while the others have been retained as APO.
You would like to say demotion, but the substantive post is TA.
Of course, my lord. My lord, as is the case with others, as with the extension officers, their substantive posting is extension officer. But they have been absorbed as APO, as were we earlier. Now only
They have been wrongly absorbed. If they have been wrongly absorbed as APO,
my lord.
do you mean to say that you also should be given the same benefit?
My lord, that is the discrimination, my lord. We have been facing this discrimination since long.
No.
And
There is positive and negative discrimination.
my lord,
Can you equate yourself with the negative? I mean,
No,
can
my
you
lord.
pray for negative discrimination?
No, my lord. No, my lord. But what we are on is the positive part, my lord. That is, earlier, we have been given to understand that the posts of APO will be filled up from TA, pursuant to Lordship's directions earlier in 2016. And accordingly, we have been allowed to function as APO.
Please write down. Anything you would like to submit, Mr. Please you notice? Yes. And Mr. P.D. Nair, Learned Counsel through RBC, who submits that the petitioners are agreed with the order dated 1/5/2025, bracket annexure 7, by which they have been shown to be absorbed as TA. No, you read as technical assistant. Within bracket, what is IWPP? DP? Interior Water Integrated Water Development Program. Bracket, you write separately TA IWDP. Stop. The Learned Counsel submits that the petitioners were submits that prior to the District Rural Development Agency,
Yes, my lord.
bracket DRDA, being merged with the Rural Development, bracket RD Department, is it? Rural Development Department, bracket RD. The petitioners, although in the substantive post of TA, bracket RE, were allowed to function as APO RE. Stop. On the merger of DRDA with RT, White order dated 22/2/2024, the petitioners were shown to be absorbed as, is it absorption?
Yes.
Yes.
Absorbed as APO, bracket RE. And the names appear at serial number 74, 63, and 64, respectively. Stop. However, by the impugn order dated 1/5/2025, they have now been shown as TA, bracket IWDP. Stop. Insofar as there are any private respondents? No.
No, man. No.
No private respondents. Okay. The Learned Counsel submits that whereas those who were functioning as EO, extension officer, in the Department of RD, which is a lower post than TA, they have been shown to be absorbed as APO, bracket RE. Stop the same has resulted in gross discrimination. And agreed, the petitioners are before this court. We have sought post up recruitment rules also.
My lord, some formulation, my lord, if I understand, my lord, the limitations, but
The petitioners have also prayed for framing of appropriate recruitment rules for the post of APO bracket RE, since the admitted fact is that there is no recruitment rules for the same post as of today. Next, warrant of publication of this motion, turnable by votes. Send Ratan Lanet additional advocate general accept notice on behalf of all the respondents. And therefore no formal notice is required. Stop petitioners shall, however, furnish requisite copies of the petition. The Lanet AAG within 2 working days. By Monday.
deeply obliged,
Working days. Okay.
deeply obliged.
Item number 8.
We have a lot of motions every day like this.
Not every day,
Always
but
right.
today seems a lot, it's more than expected, madam.
Yes,
Mayor Lordship.
yes.
Lordship, the petitioners here are the residents of non-recognized forest villages residing inside the Namdapa National Park. Your Lordship, they have been into the negotiation with the government of Arunachal Pradesh as well as the NNPP authority to consider their forest rights since 2010, and it's more than half a decade that the consideration has not been fulfilled by the state government as well as the forest department.
Who are the petitioners? They are the resident of.
10 villages residing inside the Namdapa National Forest Tiger Reserve. They are Yechijole, Jasudi, Sichito, Aguchi, Libodi, Yachele, Ngodi, Midodi, Musala, and Ngozaka village under the Vijayanagar Revenue Circle.
Where are they residing?
They are residing inside the territory of the Namdapa National Park.
Is that possible?
Your Honor, they have been residing prior to the creation of the Namdapa National Park. And it can be shortened from the National Census report that I have submitted as Annexure 1 and 2. And it was all stake due to the non-provide of the ST schedule tribe recognized and complaint made by the Namdapa National Park authorities. Finally, after the availing of the ST, now the process has been forwarded. Your Honor, as per the
So what is your grievance?
my grievances is to consider the rights for the Forest Rights Act.
Okay. Under what provision?
Under section 2C.
What is the name of the act? What is the name of the act?
The scheduled tribe and other traditional forest dwellers recognized in the Forest Rights Act 2006.
Under this act,
Yeah.
What kind of rights do you get?
Recognition of the forest rights, Your Honor.
Okay. And if recognition is there, you can dwell within a reserve forest also.
Yes. Your Honor. It states that primarily the resident in forest or forest land prior to the dated 13/12/2005. He must be a resident of that area
Prior to
prior to 13/12/2005.
13/12/2005. So you all have been residing there prior to this date.
Yes, sir.
So you cannot be said to be illegal settlers.
Yes, sir.
And the rights,
In fact,
Given-
we have been awarded the ST category also.
what are the name?
Your-
UGST,
Yes. Yobin community.
Yobin community.
Yeah.
So what more rights are you to be required to be given under the ST? If you have already been recognized as ST, what more rights?
Your Lordship, my village, they have also objected the consideration of declaration of my village notification also, in the very recent time.
Have you approached the authorities at any point of time?
Yes, Your Lordship.
Show me how the presentation,
Yes, Your Lordship.
where is that?
Your Lordship, may please go to page number 528. Representation dated 7/4/2010.
500 then,
528.
but there is no 500.
Your Lordship,
Last-
it must be in the another second copy,
Second volume.
second volume.
Second volume, there are two volumes.
Yes.
500 and
500. 528, Your Lordship. Yeah, Your Lordship. This is a settlement,
see, how do you expect me to read this page?
Your Lordship, it's a type copy.
It is almost blank.
Yes, type copy is
Type copy?
in the next page.
No, it's not there next page.
It's in 534. 534, Your Lordship. May I read it?
You have written to whom? Parliamentary Secretary.
Parliamentary Secretary, Environment and Forest, Government of Arunachal Pradesh. Settlement in Namdapa area, a brief history of the plight in Lishu, the Changlang district.
It's not a very brief. Your presentation comes to how many? 5 to 6 pages.
Next,
This is in 2010.
yes, Your Lordship. 2010.
Now, why are you here in 2025?
Your Lordship, we have been in the dispute for since so many decades. And in contrary is that the government of Arunachal Pradesh has not, Your Lordship, submitted the report to the Ministry of Tribal Affairs.
Okay, this Namdapa National Park and Tiger Reserve came into existence when? When did it come to existence?
It's in it was declared as Namdapa National Park in 1973,
73.
72.
Uh-huh.
And after that again, it was declared as the Tiger Reserve in 1983.
83. So how can you reside in a Tiger Reserve National Park?
Prior to the creation of the Namdapa Park, I was always there. We were resident there.
We had shown the provision which says that prior to the existence of National Park, if you are living there, then you can continue to live there. And you are referring to that, what you call, the Traditional Forest Dwellers Recognition of Forest Rights Act 2006.
Yes.
So 2006, the act came only. And since when are you there in the reserve area?
Your Lordship, I have been there since 1961. It can be ascertained from our
this one, the National Census report. And the whole Vijayanagar area, it was only discovered in 1961 and 62 itself by the Assam Rifles. It was annexed after the independence also. And we were forced to be displaced from our original villages due to the intervention of our ex-army settlers in the Vijayanagar area. And from thereupon, we have been forced to shift to the now proclaiming as the Namdapha National Park, Your Worship. And in this condition, we have to be again been displaced by the village by the Namdapha National Park authorities again. And in the very recent age, there is a notification for the highway construction, wherein the approach road and the area it's all been being covered under within the ROW, the entire village areas. So in this case, if we are displaced for the tribes, we have no lands to go in.
See, if it's a reserve, tiger reserve and all that, is it possible for human habitation in such a place? Are you not supposed to be resettled somewhere?
Your Lordship, they have tried to. They have been into negotiation for that also.
See, in other places, not here, in other states, some tiger reserve are also there. And ultimately, the reserve area, some cases are intended to be extended, but becomes too small. They want to extend it. And there are people leaving, the dwellers are there. So there is a scheme by the central government for rehabilitation to take out those people from there and rehabilitate them somewhere. And for that, they are given some resettlement packages so that they can. But in your case, you are saying that you were the original settlers.
Yes.
Reserve was declared later on. So how do we go about this case? Learned AG, additional AG, what would you say?
This Vijayanagar,
It's in which district? Changla.
It's in Changlang district, Your Lordship.
Vijayanagar is the last, I think, district. After that is
Nagaland border,
no, madam, it's Myanmar.
Myanmar.
Yes. So, as per the documentation and appointment made by the petitioner, my lord, now this Vijayanagar was my identifier, or my lord, is followed by the Assam Rifle, my lord, somewhere in 1960. And since then, they are claiming that, my lord, they are inhabited of that. Now, question comes, my lord, once the area has been, my lord, declared as a reserve forest. Now, my lord, Namdapha is a national property. It's a national reserve. Then also, my lord, is a tiger sector, tiger reserve. Now, when you see that schedule tribe, my lord, that right under that check, 1960.
Forest or scheduled tribe?
2006, I think. Yes. 2006.
2006 is that traditional forest dwellers.
Yes, madam.
Right.
Now, in that also, my lordship sees, madam, it is admitted fact, madam, the private dwellers, they have to use the resource of that reserve forest, resource only. It does not mean that they can clear the jungles, they can resettle there. They can use the resource like bamboo, then whatever minerals, small minerals. They have that right. But it does not mean that they have right to settle there. And here they are saying, my lord, since institution, my lord, without any objection, because that was declared somewhere in 1972, my lord. Rightly or wrongly, that was declared. No one objected, my lord. And now, my lord, they are saying, my lord, that they are the actual owner of that notified area.
So, my question was, can they live side by side? Like one way it's a tiger reserve and a forest reserve. Another way, people are saying that they are the settlers there.
My lord.
They should continue to stay there. Can it go side by side? Either one has to prevail.
My lord,
Either they have to be resettled somewhere else, or you have to denotify the
my
reserve
lord,
forest.
we tried from the district administration, my lord, to declare 40 blazers, my lord, within that area to be a notified area. Before that, my lord, the area has to be denotified. Now that was down by the central government. Because this national, when you say reserve forest, it's the property of the national. The central government will let that down for Malad. No, you can't declare them as a recognized village because this comes under the reserve forest. From our side, we try to recognize them.
All right, you bring those on record. With this time,
Now,
this
the
issue.
central government, my lord, it's up to them. If they denotify, my lord, we can go ahead.
Please you notice at this stage only.
Lordship, please, Lordship may see page number 551. 51 euros. 51. This is the monthly update of status of implementation of the Scheduled Tribe and other traditional forest dealers recognized of Forest Rights Act 2006. Here it is, the government of Arunachal Pradesh has provided information that the state government has informed that Arunachal Pradesh is a 100% tribal dominant state, and almost all the lands are wholly possessed by the various ethnic tribal groups. As such, there is no instance of eviction of forest dwellers who has been dwelling in the forest even before the implementation of the Act 2006. Consequently, there are no claim of the forest received under the Act 2006.
What is
Whereas they have already, we have been claiming the forest land since 2001.
No, what is this document? It is a part of which document?
It is the part of the issued by the Ministry of Tribal Affairs. Monthly update of status of implementation of Scheduled Tribe and other traditional forest dealers recognized the Forest Rights Act 2006. It is the last update of 31st March 2022. They have not mentioned our name that we are claiming the forest, we are claiming our rights over the Namdapa National. Whereas we have been fighting since 2010 itself, and we have been forcefully been evicted from our villages since 2011. It is an action, Your Lordship, in a series of
All right, we'll examine your claim. All right, Mr. You are Mr. What? Learned counsel for the that. By filing this writ petition, the petitioners for land rights to them in view of they being the residents of traditional forest dwellers. Belong. Yache Jolo, Josadi, Sichoto, Aguchi, Nibodi, Yachele, Nagodi, Midodi, Musala, and Wazaka. In Vijayanagar Revenue Circle of Changlang District. the state of Arunachal Pradesh. Page 6, you'll get it. This next. United Council submits that the petitioners have been submitting their presentation from time to time, claiming such benefits. But however, the respondent authorities have failed to take any appropriate steps and instead have been trying to evict them from their respective dwelling. The above issue of motion returnable by votes. Mr. Arish Nawab, additional occasional exception of the on behalf of respondent.
Fellowship, 2, 5, 2, 5 to 12.
2, 5 to 12. And Mr. M. Katul on the TSGI exception notice on behalf of respondent number 1 and 3. What about what is 3 on the What about Principal Secretary, Forest? 4. State government. I think 4. So 4 from 4 to
4 to 12.
4 to 12, Mr. Arish Nawab. Okay. And as such, no formal notice is required. Petitioners to furnish requisite copies of the writ petition. Learned councils are paying for the response today.
The lordship intimated that there might be a forceful eviction. As they have the circular noticed on the 17th April 2005.
Who is there?
Page 695. 90. 690.
600.
Second volume, madam.
693.
Your lordship. May I read out the lordship?
No, not required. This is attending a meeting, circular.
Circular.
Your lordship. It's a pending disposal of the minutes of the meeting, your lordship. Earlier they have evicted us.
No, where is the apprehension that you'll be evicted and by which order? There's no such order.
For the concept of relocation, rehabilitation.
Uh,
They want
No, where's the question of status quo? There's no such apprehension as such. If you have the apprehension, you will come again by filing appropriate application. And the court will definitely consider. This is the matter again after 4 weeks. Respondents to file their returns by then.
The lordship.
Item number 9.
Marvelous.
Yes.
My lord, I have a limited prayer. Here in this case, my lord,
Where you have your
My lord, here in this case, I filed a representation before the Deputy Commissioner, Kamaliman, and that has not been attended.
What's the representative?
The representation was trying for taking a legal action against some particular town borough of my place. So I'll take the lordship to the page number 14 is my representation, and my lord may kindly come to page number 16. Main principal contention of my representation. Page 16, my lord. For and along with me, the other GB and the villagers are ready to give the testimony that the judicial system of the customary court has been illegally commercialized by the 2GB. Hence, the public has now no more trust upon the said 2GB. For that the manufacturers of the decision against me, his campaign has made to the other GB to put their sign and try to manipulate them. That the powers of the GB should be used for their will, irrespective of the merit of the case.
Okay, just a minute, 1 minute. Who appoints the GB
My lord, Deputy Commissioner,
and who is the controlling department? Which is the controlling department?
Deputy Commissioner,
No, above Deputy Commissioner. Deputy Commissioner comes under what?
it's come under my lord,
JD.
District and State.
Sorry?
GA, General Administration.
GA. Now, supposing the Deputy Commissioner fails to take some action, what is the next step? In such kind of election. This is a nomination, isn't it? GPs are nominated.
Well,
Nominated. Who has the authority to nominate them?
Selection.
By selection. Who selects the GP?
And that's okay.
Elders. And the Deputy Commissioner approves it.
yes, final
Over.
approval is the Deputy Commissioner.
Is having a right with the GB also. And then the petitioner is the one who complained.
Some personal grudges are there.
Yeah.
So that's why I was trying to find out
It starts.
what is the manner in which the GPs are being appointed.
My lord,
One is complaint Texas against the GPs, and then they are terminated. Then we ask for the termination also. This is
But
there are signatories that's different.
this is a very recent one, 25/8.
Yes. August 25. This is not one month.
but my lord, why I am before the lordship manner, that the
So we dispose it of
Fine.
by asking the Deputy Commissioner to consider and dispose it of.
that must, my lord.
Okay, heard Mr. C. Modi, learned counsel for the petitioner. And Ms. G. Ate, learned additional senior governor advocate. Now, having regard to the grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Stop. It is the case of the petitioner that the GPs are there.
Allegation is against the people.
2 GB only, man.
They are respondent here.
No, man.
Her sister is the other side of the bank party is also.
So is that some Nagura, that GB of Dari village have committed are indulging in making are indulging in manufacturing decision and extorting the litigants in the name of KEBA fees. Stop. In view of such abuse of power, the petitioner had submitted a representation before the Deputy Commissioner Dikabali Lawarsiang on 25/8/2025. But since the same has not been considered and disposed of, the petitioner is before this court. Mr. C. Modi, learned counsel for the petitioner, submits that the representation filed by the petitioner is not against the decision taken by the GBs, but against the conduct of two GBs in particular who have been named in the representation dated 25/8/2025. Next paragraph. Ms. G. Ate, learned additional senior government advocate, submits that the representation submitted appears to be in the form of certain personal grudge made against certain GBs. And in such circumstance, the Deputy Commissioner cannot be expected to attend to each and every complaint made on a particular GB. So moreover, the complaint has been submitted as recent as on 25/8/2025. And therefore, the writ petition appears to be premature. So next para, having heard the learned counsels for the rival parties, upon perusal of the materials available on report, it is seen that the sole grievance of the petitioner is with regard to non-consideration of his representation filed on 25/8/2025. And such being the position, this court has finds it do not find any impediment directly authority concerned to consider the same within time frame by passing appropriate orders. Next para, in view of the Deputy Commissioner Dikabali, Lawarsiang District, is shall consider and dispose of the representation filed by the petitioner on 25/8/2025 by way of passing a speaking order within a period of how much time?
1 month.
1 month from the date of receipt of a certified copy of this order. Sentence shall dispose of. No, before that, by way of before that, you just put just insert before by by, insert this words in accordance with law by way of so and so. All right.
All right.
Item number 10.
Here is the defect in the post title manner. State of India cannot be represented by the managing director, the National Highways and Infrastructure Development Corporation. Corporation is corporation, madam. They cannot represent on behalf of the Union of India. And moreover, madam,
What will be the correct nomenclature? The Secretary to the Government of India, MOTH.
managing director cannot.
Maybe allow to correct that for title.
Oh.
Yeah.
You will have to file an application for that. There's a circular already. Says that any corrections required has to be filed for the application. We'll withdraw this. You file one IA, that'll be easier. Just say that these are the things you go ahead, and IA will be considered and allowed, and then you file the amended cost. That's paid for by Mr. Bhattacharya. It's the matter again, when after a week. In the meantime, the learned council may file an application for correction of the cost title. It's advice.
Item number 11.
Yes, what is this matter?
My lord, the petitioners herein, my lord, are the MTS serving multitasking staff who are serving under various districts of Siang. Various establishments under Siang district, Arunachal Pradesh, my lord. And they have not received the salary since the month of October 2023, my lord. And that is the grievance you have brought forth with this petition, my lord. And my lord, annexure number 2 is the regularization order. Page number 26 is their regularization order of
What do you call them?
multitasking staff. MTS, my lord.
MTS.
Yes, my lord.
Appointed since when?
Appointed, my lord. They have been appointed on different dates. One, petition number 1, 2, and 4 were appointed.
You have made a chart.
No, my lord.
But you have made a chart. There are how many petitioners? 6 of them.
My lord, 6 months.
Petitioner 1 and 2.
1, 2, and 4 were regularized.
No, appointed when?
Appointed. My lord, regularization serves as appointment only, my lord.
1, 2, and
1, 2, and 4 were regularized on 20/04/2018, my lord. 20 April 2018.
Okay, then.
Then, my lord, petitioner number 5 was regularized on 11/01/2018. 11 January 2018. And 6 was regularized on 26 February 2018.
Please show me one regularization order.
26, my lord, page number 26. This is petition number 1, my lord. In pursuance of government approval, Sri Boken Taten continues paid staff is hereby regularized as MTS in the pay matrix level 1, cell 1 of rupees 80,000 per month plus other allowances as admissible. Under the rules from time to time in effect from the date EC actual reports were decreased under the disposal of DTC complement period. Now, the posting order are given in annexure number 6, page number 36 to 41, my lord. My lord, the entire crux of the matter, my lord, is the main crux of the matter, my lord, is this termination order, which we have brought in an additional appeal. In the month of the year of 2023, my lord, November, there was a huge controversy, my lord, surrounding the appointment of MTS. And thereafter, a list of term staff who were appointed illegally was given, my lord. This is
So your case appeared to be regarding non-payment of wages. Now it comes to what, termination?
clarifying the scenario we're facing, my lord. We're just clarifying how
You're no more there serving, isn't it? You're terminated.
We're serving.
Then why the termination order?
This is controversy surrounding the whole thing. That's why we are clarifying the scenario, the circumstances, my lord. In 2023, my lord, this list was given, my lord, wherein several group people of MPS were terminated, my lord. And in this list, my lord, I would name the petitioner's name are not there. And thereafter, there was this letter, annexure number 11, my lord, 53. There's this letter issued to by the SIC Vigilance, my lord, wherein they have noted our name. One is Miss Yamen Pangu, who is also a petitioner here. Number 2 is also Miss Amoti Pari, who is also a petitioner herein. 3, 5, 13, and 16 are petitioners, my lord. And against them, the remarks have been given. However, there has been no proceeding after that, my lord. And
No, what remarks? What is this?
remarks as in from the SIC Vigilance that no such file was generated or created in the directorate observation.
What does it mean?
It means that there is no such file which is before the office, my lord. That
So your appointment is also without any basis.
no, my lord.
Then what?
Because this was later cleared out, my lord.
Huh?
This was later cleared out in after we have
No, the
given
heading,
legal
the subject says recommendation for departmental action.
yes, my lord. There was no further proceeding after that.
So you were under scanner.
Yes, my lord. We
You were under the scanner, but they didn't find anything.
no, my lord. And they cleared it out later, my lord. It can be seen in annexure number, my lord, 14. Page number 64, my lord, 64. Annexure number 14, my lord. This is to the director of we have served a legal notice, that's annexure number 13, and thereafter they have replied to our legal notice, my lord. And here it is shown in the, my lord, after the paragraph, after the box, my lord, after the, it says, hence on verification, the appointment is considered genuine. Further order may be issued to this establishment for release of their salary, my lord.
Now, these names are the petitioners.
Yes, my lord. Yamen Pangu, Yasek Pangu, Amoti Pari, these are
All of them.
all of them, my lord. 6 petitioners, we have also served a legal notice, that's why, my lord. And this has cleared out the scenario, my lord. And our doubt,
And your
Or
salary is
apprehension.
pending since when?
it's since pending since October, my lord, October 2023, my lord.
Since October 2023,
Yes,
you are
ma'am.
not given your salary.
Yes, my lord. November 2023, my lord.
November.
Yes, my lord.
What was the allegation otherwise?
Allegation is that our appointment was illegal, my lord.
Illegal appointment.
Yes, because there was a major controversy during the time wherein several people were terminated, my lord. And that is our apprehension, my lord, is that because of that confusion and
You were appointed as MTS.
MTS, my lord,
By whom?
by the
You have not given the
Government of Department of Elementary Education, my lord.
No, you have not given the initial appointment. That's what this is just what regularization.
What appointment order is there, my lord? One appointment order.
Yes, where is it?
There is in page 35, my lord. One appointment order, my lord.
35.
Yes, my lord. There is an appointment order of one of the petitioners, my lord.
Who is he?
He is Nalo Mugabang. He has not been regularized, my lord.
Oh, petition number.
Petitioner number.
Is he one of the petitioner?
Yes, my lord. He's one of the petitioners. His petitioner number.
Nalamibang.
His petitioner number 3, my lord. He has not been regularized, but his appointment that hence we have put his appointment order, my lord.
So all the petitions are not regularized.
Yes, my lord.
His name also appears in that 64.
60.
Nalamibang. Yes, he's there.
Yes, my lord. 64 it appears, my lord. We have served a legal notice on their behalf. And after they came back with this reply saying their salary may be released, but after also there has been no action, my lord.
So your appointments are in fact at the directorate level or it's with the government?
It's with the government, my lord.
because page 35, annexure 5, which you just shown me,
Yes, madam.
it says copy to Secretary Education, PA Secretary for information, then Director, everything is there. Then there's no petitioner number 3 has been appointed on compassionate basis.
Yes, madam.
What about the others?
There,
If you see page 35,
yes, madam.
before the signature given by Tapigao, this issue with the approval of the government, right? So and so, so and so. Now, when you come to the regularization or there is no such kind of government's approval. And now you are showing me page 64, saying that there's a clearance now. But the clearance has come from the deputy director to the director.
Office of Deputy Director of School Education, Bangladesh. And it's come from Deputy Director of School Education.
Who was the council for education? Tagum. He's not come today. He was here.
He was here, madam.
Why, what happened? Art Mr. MP, Mr. M. Patin.
Yes, madam.
Learned counsel for the petitioners. Suppose that the grievance of the petitioners is that they have not been given their salaries since the month of November 2023 till date, despite clearance given by the respondent authority concerned. As regards their appointment as MTS. So, in this regard, the learned counsel has drawn the attention of this court. The letter dated 2/6/2025, written by the Deputy Director of School Education, Siang District, Boleng, to the Director of Elementary Education, Government of Arunachal Pradesh. Issue notice of motion, tenable by 4 weeks. Petitioner to take steps for service of notice upon the respondents. No, cancel that. Notice be served. Who are the respondents?
All education department.
Notice be served upon all the respondents to Mr. T. Tagum, Learned Standing Council Education Department, by furnishing him requisite copies of the writ petition. The petitioners shall obtain the acknowledgement of receipt of the writ petitions and submit the same before the registry as proof of service. This again, after 4 weeks, pendency of the writ petition shall not be a bar for the respondents, at least the salary of the petition.
Item number 14.
Then you have to find it. Yeah. So,
How much time? Okay.
sit there, instruct. What's the-
My lord, I am for the petitioner.
Dr. Puja?
Dr. Puja, but your lordship, I have a small prayer. In this may be last opportunity given to the opposite party, because since the matter is pending from the 23.
Yes, plus chance.
What's it?
4 weeks.
Yes, no.
4 weeks time is granted to the government to the respondents to file their counter affidavit as a last chance.
Okay.
List again after 4 weeks.
Item number 20.
Come up with the addition for the second time of the file it.
How much time?
After Puja prayer.
After 4 weeks. So how you say it's wrongly listed? Notice only had gone, so
This is second, so.
no, it's okay. That second time, but it can be listed under admission column also. So supposing it was admitted by issuance of rule, then of course it should have come for orders or for hearing. I don't know. But now it has come for admission, and notice was only issued last time. Ms. G. Adele on it. Additional senior government advocate submits that. This is the second time only that the matter has been listed. Therefore, she may be granted 4 weeks time. Okay, instructions at the file on time today. Where's the number? List again after 4 weeks. Your good name? Mr.
Ibam,
Ibam
appearing on
Lanet.
behalf of RE.
Ibam Lanet Council appears on behalf of Mr. R.
No.
Ingo. Council for the petition.
This may have listed some shorter period.
Why? Why?
It's for the instruction from senior. Sorry.
So that's okay. See, you are having puja vacation for 3 weeks anyway.
Yeah, 3 weeks
So
maybe.
even if I say 2 weeks also, it'll come after puja only.
Yes.
Same thing. Yes. And more or less the second time.
Item number 21.
What is the matter regarding? They were functioning as JE. That's what. On what substantive basis? No, question is, are they holding the post of AE on substantive basis or it's only officiating basis? Then what grievance can you have?
So, there is a guideline of government. Promotion.
85. All of them are JE. Paper publication. Is it on 2 local dailies or 1 local daily? 1 for 2 consecutive days. It's easy to say. Supposing the person does not read newspaper on that day, so at least to be on the safe side, normally court directs on 2 local papers and 2 consecutive days. But in your case, we'll make it 1 local daily, but 2 consecutive days. Mr. A. Bhattacharjee, learned counsel for the petitioner, submits that. How many petitioner? One. Ms. Bangu, you are there for the government. See, since private respondents could not be served, we're directing that let there be paper publication for 2 days in local paper. Submits that despite the attempt for service of notice upon the private respondent numbers 4 to 88, notice could not be served. And therefore, he prays that the petitioner may be allowed to make newspaper publication. Last line, you just remotivate. And therefore, he prays that petitioner may be allowed to serve notice to the private respondents in a substituted manner by making newspaper publication. Stop in view of above. Petitioner to serve notice to the private respondents by making newspaper by way of newspaper publication in one local daily, widely circulated in the state. For 2 consecutive days and through the registry of this court. Showing the next court date at the paper publication be done 10 days from today. Stop. Once the paper publication is done, the petitioner shall file copy of the newspaper publication by way of an affidavit as proof of service in a subsequent manner. This is the matter of 3rd of November. Ms. P. Bangu, Planet State Council, appears for the respondent numbers 1, 2, and 3, and the respondents and the respondents she represents. You have not filed counter, isn't it? Okay. Okay. Then not required. Only her appearance.
My lord, I'm extremely sorry, my lord. At number 11, I could not represent. I was a BC man. Election matter, madam. My name and madam. I could not represent, madam. Standing council education.
No, it's okay, but I've asked the council to serve you
Mind the
copy. You just give your acknowledgement and he will submit it.
Keep your
Item number 22.
in item number 22, as per the instruction, madam, is under process for payment of the madam. The approval has been for approval. The bill has been changed to the higher authority.
When?
Yes. The last month, the first part of this month. Within a month, madam.
Give your instructions.
How you get there for madam, may only pray that madam, when we listed up job petition in that month. But we have already filed epidemic.
Okay, but regarding you're saying that the bill has been sent and all that, where is the proof? Give me a copy of that.
By the deputy commissioner. Other meeting, have been already paid to the Malada petitioner. But time and again, they are making modified of the Malada claim. Finally, they settled the tune of 2 crore. Just 2 crore. It is mentioned 2 crore.
This is from the DC to the,
But that has been sent to the Malad higher authorities.
When?
That is not Malad given. It is.
okay, we'll give you time. Give him some time.
We are ready to pay, man.
Parties are represented by the respective councils. Mr. M. Katol and GSGI is there. The process, the payment of compensation to the petitioners is under process. And it is only within due course of time that the amount will be disbursed to them. So we therefore praise that he may be given 3 weeks time to come up with the up-to-date status. Considering the submission, let the matter be decided after the application.
Item number 23.
Petitioner also have taken step after the other respondent. Taken up to the private respondent or not, but our part, we have already sent the copy.
How many private respondents are there?
Yes.
4, 2, 4, 5.
Four, 5, 7, 8, 9, and 10, private respondent. All private individual, of course, they are serving under the ITBP.
How about 6? Okay.
They are ITBP personnel. However, made as a party on individual capacity. Private respondent number 4, 5, 7, 8, 9, and 10. And I'm for the officer respondent 1, 3, and 6.
Please write none appears for the petitioner. Mr. M. Katol on it, ESGI appears for the respondent numbers
1, 2, 3, and 6.
1, 2, 3, and 6. Stop office note dated 12/9/2025 indicates that respondent numbers 4, 5, 7, 8, 9, and 10 have been served notice through the CJM cum civil judge, senior division, Alo. This is accepted to be complete upon the private respondent's consent. So, however, since no one appears on their behalf, that the matter will be stated again after the NCP application.
Item number 24.
My lordship. Lordship, service against respondent number 7 and 8 is still limited. Lordship, I may be allowed to file the justice service report in the form of affidavit.
7 and 8.
Lordship, I serve through the dusty and I may be allowed to file.
What is 7 and 8?
Private respondent.
That prayer is already there. You were already allowed, it seems, as per the office note. Dusty.
Lordship, I may be allowed to, Lordship, that's service reporting.
Now you're supposed to file an affidavit only, that's all.
Lordship,
When will you file?
Lordship, one page. After vacation,
Have you served or not? That's the question.
Lordship, I serve.
When?
Lordship, through, WhatsApp, client give me the report.
There must be a date also on when you served. And the respondents are 5, 6, 7, and 8.
No.
Correct.
No, sir.
Dusty. Madam, you are for. Learned counsel for the petitioner submits that notice by way of Dusty has been served upon respondent numbers 5, 6, 7, and 8 on 20.
3/16.
On 23/6.
No, Lordship, it's a receipt date.
Okay, don't give the date. Has been served upon this respondent number so and so. And he prays for a week's time.
Lordship.
A week's time to file that affidavit. Incorporating the notice served by Dusty. To incorporate the notice served by Dusty. Prayers allowed. Ms. G. Wongo, learned government advocate, appears for the response numbers 1 to 4. Have you filed affidavit? Submits that affidavit and position has already been filed by the respondents she represents. You forgot this the matter again after.
Puja.
So you could have a
Lordship, there is an interim order. Maybe.
interim order passed earlier. Shall continue till the next date of this.
Okay.
Item number 25.
Lordship, this is for condoning the delay of 11 days in filing an appeal under section 37 of the arbitration and conciliation.
Who is the respondent? Notice will have to go. It was the first time.
Yes.
But Mr.
Jiva.
G. Pato.
Yes.
Learned counsel for the applicant who submits that by filing this application, the applicant seeks condonation of 11 days delay in filing the connected appeal